Hi guys, good morning. Now today's morning time is 6 o'clock and I'm creating this video early morning to give you knowledge about the Customs Act 1962. The Customs Act 1962 is implemented from 1st February 1963. The act is very important if you are customs broker or doing import or export business. So you must have the knowledge about the Customs Act 1962. If you don't have basic knowledge about the Customs Act 1962, you will face a lot of difficulty in the customs clearance of the imported and export goods. So guys, please watch my videos till the end and expand your knowledge about the Customs Act 1960. I'm giving you thoroughly knowledge of the Customs Act 1962, so you have to listen my videos carefully. You can listen my videos while traveling and doing other activities. As a working professional, you don't have that much time to read the books. So I have decided to create a videos for working professionals like me. So guys, please subscribe to this channel if you are watching my videos first time and share with your friends if they needed knowledge about the Customs Act 1962. In the previous video, we have seen some sections from the chapter number 15, Appeals and Revision. In the same, Section 128 is Appeal to Commissioner Appeals. Section 128A is Procedure in Appeal. Section 129 is Appellate Tribunal. Section 129A Appeals to the Appellate Tribunal. Section 129B Orders of Appellate Tribunal. Section 129C Procedure of Appellate Tribunal. Section 129D Powers of Committee of Chief Commissioner of Customs or Principal Commissioner of Customs or Principal Commissioner of Customs or Commissioner of Customs to pass certain orders. So these sections we have already seen in the previous videos. If you want to watch these videos, please listen to my channel and in the playlist Customs Act 1962, you will get my all the videos of the Customs Act 1962. So guys, please listen carefully and listen videos again and again to improve your knowledge about the Customs Act 1962. So in this video, we are going to see sections from 129DA. So section 129DA is omitted. So next section is section 129DD. Section 129DD is revision by central government. Section 129E deposit of certain percentage of duty demanded or penalty imposed before filing appeal. Section 129E interest on delayed refund of amount deposited under Section 129E. Section 130 is appeal to High Court. Section 130A is application to High Court. These sections we are going to see in this video. In the same section 129DD revision by central government. Subsection 1, the central government may, on the application of any person aggrieved by any order passed under section 128A, where the order is of the nature referred to in first provision of subsection 1 of section 129A, annul or modify such order, provided that the central government may, in its discretion, refuse to admit an application in respect of an order where the amount of duty or fine or penalty determined by such order does not exceed 5,000 rupees. Explanation. For the purposes of this subsection, order passed under section 128A includes an order passed under that section before the commencement of the section 40 of the Finance Act 1984, against which an appeal has not been preferred before such commencement and could have been, if the said section had not come into force, preferred after such commencement to the appellate tribunal. Subsection 1st. The principal commissioner of customs or commissioner of customs may, if his opinion that an order passed by the Commissioner appeals under section 128A is not legal or proper, direct the proper officer to make an application on this behalf to the central government for revision of such order. Subsection 2. An application under subsection 1 shall be made within 3 months from the date of the communication to the applicant of the order against which the application is being made, provided that the central government may, if it is satisfied that the applicant was prevented by sufficient cause from presenting the application within the appropriate period of 3 months, allow it to be presented within a further period of 3 months. Subsection 3. An application under subsection 1 shall be in such form and shall be verified in such manner as may be specified by rules made in this behalf and shall be accompanied by a fee of clause A 200 rupees, where the amount of duty and interest demanded, fine or penalty levied by an officer of customs in the case to which the application relates is 1 lakh rupees or less. Clause B 1000 rupees, where the amount of duty and interest demanded, fine or penalty levied by an officer of customs in the case to which the application relates is more than 1 lakh rupees, provided that no such fee shall be payable in the case of an application referred to in subsection first A. Subsection 4. The central government may, of its own motion, annul or modify any order referred to in subsection 1. Subsection 5. No order enhancing any penalty or fine in lieu of confiscation or confiscating goods of greater value shall be passed under this section. Clause A. In any case in which an order passed under section 128A has enhanced any penalty or fine in lieu of confiscation or has confiscated goods of greater value. Clause B. In any other case, only the person affected by the proposed order has been given notice to the show cause against it within 1 year from the date of the order sought to be annulled or modified. Subsection 6. Where the central government is of the opinion that any duty of customs has not been levied or has been short levied, no order levying or enhancing the duty shall be made under this section unless the person affected by the proposed order is given notice to show cause against it within the time limit specified in section 1, section 28. So section 129 double D revision by central government. Section 129 E deposit of certain percentage of duty demanded or penalty imposed before filing appeal. In the same, the tribunal or the commissioner appeals, as the case may be, shall not entertain any appeal. Clause first, under subsection 1 of section 1 to 128, unless the appellant has deposited 7.5% of the duty in case where duty or penalty are in dispute, or penalty where such penalty is in dispute in pursuance of a decision or an order passed by an officer of customs lower in rank than the principal commissioner of customs or commissioner of customs. Clause second, against the decision or order referred to in clause A of subsection 1 of section 129A, unless the appellant has deposited 7.5% of the duty in case where duty and penalty are in dispute, or penalty where such penalty is in dispute in pursuance of the decision or order appealed against. Clause third, against the decision or order referred to in clause B of subsection 1 of section 129A, unless the appellant has deposited 10% of the duty in case where the duty and the penalty are in dispute, or penalty where such penalty is in dispute in pursuance of the decision or order appealed against, provided that the amount required to be deposited under this section shall not exceed rupees 10 crores, provided that the provisions of this section shall not apply to stay applications and appeals pending before any appellate authority prior to the commencement of the Finance Number 2 Act 2014. So, Section 129E deposit of certain percentage of penalty and duty demanded before filing appeal. So, Section 129E deposit of certain percentage of duty demanded or penalty imposed under before filing appeal. So, Section 129E interest on delayed refund of the amount deposited under Section 129E. So, in the same, where an amount deposited by the appellant under Section 129E is required to be refunded consequent upon the order of the appellate authority, there shall be paid to the appellant interest at such a rate not below 5% and not exceeding 36% per annum as is for the time being fixed by the central government by notification in the official gazette on such amount from the date of the payment of the amount till the date of refund of such amount. provided that amount deposited under Section 129E prior to the commencement of the Finance Number 2 Act 2014 shall continue to be governed by provisions of Section 129 EE as is stood before the commencement of said Act. So, Section number 130 Appeal to High Court. Section 130 Section number 130 Appeal to High Court. In the same subsection 1, an appeal shall lie to the High Court from every order passed in appeal by the appellate tribunal on or after the first day of July 2003, not being an order relating among other things to the determination of any question having a relation to the rate of duty of customs or to the value of the goods for the purposes of assessment. If High Court is satisfied that the case involves a substantial question of law. Subsection 2. The Principal Commissioner of Customs or Commissioner of Customs or the other party aggrieved by an order passed by the appellate tribunal may file an appeal to the High Court, and such appeal under this subsection shall be Clause A filed within 180 days from the date on which the order appeal against is received by the Principal Commissioner of Customs or Commissioner of Customs or the other party. Clause B accompanied by a fee of 200 rupees where such appeal is filed by the other party. Clause C in the form of a memorandum of appeal precisely stating therein the substantial question of law involved. Subsection 2A, the High Court may admit an appeal before the expiry of the period of 180 days referred to in Clause A of Subsection 2 if it is satisfied that it was sufficient cause for not filing the same within that period. Subsection 3 where the High Court is satisfied that a substantial question of law is involved in any case it shall formulate that question. Subsection 4 the appeal shall be heard only on the question so formulated and the respondent shall at the hearing of the appeal be allowed to argue that the case does not involve such question, provided that nothing in this subsection shall be deemed to be take away or abridge the power of the court to hear for reasons to be recorded. The appeal on any other substantial question of law not formulated by it, if it is satisfied that the case involves such question, subsection 5, the High Court shall decide the question of law so formulated and deliver such judgment thereon containing the grounds on which such decision is founded and may award such cost as it deems fit. Subsection 6. The High Court may determine any issue which Clause A has not been determined by the appellate tribunal. Clause B has been wrongly determined by the appellate tribunal for reasons of a decision on question of law as is referred to in subsection 1. Subsection 7 where an appeal has been filed before the High Court, it shall be heard by a bench of not less than 2 judges of the High Court and shall be decided in accordance with the opinion of such judges or the majority if any of such judges. Subsection 8 where there is no such majority, the judges shall state the point of law upon which they differ and the case shall then be heard upon the point only by one or more of the other judges of the High Court and such point shall be decided according to the opinion of the majority of the judges who have heard the case including those who first heard it. Subsection 9. Save as otherwise provided in this Act, the provisions of the Code of Civil Procedure 1908 of 1908 relating to the appeals to the High Court shall, as far as may be, apply in the case of appeals under this section. So, Section 130 is appeal to High Court. Section 130A application to High Court. In the same subsection 1, the Principal Commissioner of Customs or Commissioner of Customs or the other party may, within 180 days of the date upon which he is served with notice of the order under Section 129B, passed before the first day of July 2003, not being an order relating, among other things, to the determination of any question having a relation to the rate of duty of customs or to the value of the goods for purpose of assessment, by application in the prescribed form accompanied where the application is made by the other party, by a fee of 200 rupees apply to the High Court to direct the appellate tribunal to refer the High Court any question of law arising from such order of the tribunal. Subsection 2. The Principal Commissioner of Customs or Commissioner of Customs or other body applying to the High Court under Subsection 1 shall clearly state the question of law which he seeks or be referred to the High Court and shall also specify the paragraph in the order of the appellate tribunal relevant to the question sought to be referred. Subsection 3. On receipt of that application has been made under subsection 1, the person against whom such application has been made may, notwithstanding that he may not have filed such application, file within 45 days of the receipt of the notice or memorandum of cross objections verified in the prescribed manner against any part of the order in relation to which an application for reference has been made, and such memorandum shall be disposed of by the High Court as if it were an application presented within the time specified in subsection 1. Subsection 3. The High Court may admit an application or permitting filing of a memorandum of cross objections after the expiry of the relevant period referred to in subsection 1 or subsection 3 if it is satisfied that there was sufficient cause for not filing the same within that period. Subsection 4. If an application under subsection 1, the High Court directs that the appellate tribunal to refer the question of law raised in the application, the appli- the appellate tribunal shall within 120 days of the receipt of the such direction draw up a statement of the case and refer it to the High Court. So section 130A is application to High Court is also very important in the chapter number 15 appeals and revision. So in this video we have seen section 129 double D revision by central government, section 129E deposit of certain percentage of duty demanded of and penalty imposed before filing appeal, section 129 double E interest on delayed refund of amount deposited under section 129E, section 130 appeal to High Court, section 130A application to High Court. So these sections we have seen in this video. Next upcoming sections of the chapter number 15 appeals and revision we are going to see in the next video. Till then, bye bye and take care.